Hello guys, welcome to another session. In today's session, this is in fact going to be one of the most important building blocks in your UPSC preparation, polity preparation. See, we are going to discuss or we are going to dive deep into some core constitutional concepts, and we'll start with the meaning of keywords in preamble, and then we move to different types of majorities, and then we will also discuss about fundamental rights, duties, and DPSPs, and we'll also take a look at the landmark Supreme Court judgments. So I know you might have confused by complex terminology or the overlapping concepts, but I can promise you that after the session, you will get some good clarity and confidence on all these topics that I have discussed about. So let's start with the preamble. Every word here has a weight. For instance, when we talk about liberty, it's not just a feel-good term. It actually protects us from or against the arbitrary action by the executive or even the legislature. So we will talk, in fact, about this more when we discuss fundamental rights. So we will get into that. This is a very important topic that we need to cover. So it has its own significance also. When we talk about fraternity, which means brotherhood, which means social harmony among the citizens. And then there is equality in the preamble that actually refers to in terms of both status and as well as opportunity. So, which is why we will later differentiate between equality before law and equal protection of law. So, I will be this, in fact, I need to discuss in detail. If possible, today, end of the session, also, I'll do that. When we talk about justice here, that includes social, economic, and also the political justice, which will come into picture. So I need to exclusively mention all these things in detail. We'll come to that. And again, the term republic, that simply means our head of the state is elected, not hereditary like UK. So take every preamble word seriously. In fact, it means a lot, starting from liberty, equality, fraternity, republic, justice. Everything have that much weight into that. So, in fact, they can be directly asked also each and every word they can pick up, and they can, in fact, ask questions from each and every words. In fact, almost all these are connected with the fundamental right also, especially that Article 21. So, I'll be coming to that in detail. Now, let's try to quickly understand the majorities. Okay, so different types of majority which is used in parliament. First, the simple majority, right? So let's say if 100 members are present and voting, what does that mean when it comes to simple majority? 51 is enough to pass a bill. So it's calculated based only on those who are present and voting. So this number, in fact, can vary. If 200 members are presenting and then voting, which means 101 will be the majority. So it depends upon that presence, right? So this number can vary. Now, when we talk about absolute majority, so this is actually based on the total strength of the House. So 545 members. So more than 50% means 50% of 545, which is 273. So this number is fixed. So when we talk about simple majority, that depends on the members who are present and voting. That means it can vary because not everybody will be present, right? But when we talk about absolute majority, that's the total strength of the parliament, that's fixed as 273, which is more than 50%. When we talk about effective majority, that's similar to absolute majority, but what we do is we subtract the vacant seats there. Let's say 5 seats are vacant, and then total then 545. That's the total strength. So 5 are vacant, which means 540. So effective majority means 50% of 540. That vacant seats we will exclude, which will be 271. So here it's almost similar to absolute majority, but we exclude that vacant seat. Now, what is special majority? See, this is the 2/3 of members who are present and voting plus absolute majority. So both conditions must be met. So special majority means it's first absolute majority, which is fixed, which is 273. At the same time, the number of members who are present and voting, out of that 2/3 also. So that's why constitution amendments that require special majority, and that makes the process very rigid. First, you need that absolute majority. Second, you need the 2/3 of the members who are present and voting. That is something which is going to be slightly difficult. That consensus is very much required. Now, let's take a quick look at the fundamental duties. Okay, part 4A of the Constitution, which is fundamental duties. Originally, there were none, right? So these duties were added by the 42nd Amendment based on the recommendation by Swaran Singh Committee. So just remember the 42nd Amendment, just remember the committee name, Swaran Singh Committee. So Article 51A contains all these duties. So remember the Article 51A, remember the part which is 4A. And only one article, but there are 11 duties. So initially there were 10, and the 11th was actually added through that 86th amendment, and that makes it the duty of the parents to send children aged 6 to 14 for education to the school. So that comes in 86th amendment, that makes a fundamental right for the children to get that education, and the duty for the parents to send the children in the age of 6 to 14 to the school for education. So these duties are not enforceable in court, but they hold that moral importance, right? So that's something which again you need to keep in mind. Questions are often asked, if you see, directly and indirectly also. So please remember all these facts which I've mentioned, like 4A, 51A, 11 number, and 86th amendment, and then the 42nd amendment and the sentencing committee, all these facts which you need to remember. So directly they will ask you, and very good scoring and straightforward. There is no need to get into any trap also here. Now, next move on to fundamental rights, which is constitutional and legal rights. So, see the basic distinction when we talk about, let's try to, this question was asked, right to vote, whether it is constitutional or fundamental or legal right. So let's try to understand what is fundamental right, what is constitutional right, what is legal right. Okay, that's very important. Let's understand that first. So when we talk about fundamental rights, which are enforceable under Article 32, which means if violated, you can directly approach the Supreme Court. So if fundamental rights are violated, go to Supreme Court directly. Okay. Again, when it comes to constitutional rights, these are also provided in the Constitution, but not part of Part 3, right? So when we talk about fundamental rights, it comes under Part 3. So directly, if it is violated, you can go to the Supreme Court. When we talk about constitutional rights, it's there in the Constitution, but not in Part 3. That's the only difference. So it's a constitutional right. Fundamental rights is also a constitutional right, but it comes under Part 3. So which is having its own significance. So for them, what you can do is you can go to High Court under Article 226, and then Supreme Court as a court of appeal. Okay, then comes legal rights. So here, this comes from the laws made by Parliament or the state assemblies. It may not be there in the, it is not there in the Constitution. So these are the laws which are made by the Parliament or the respective state assemblies, like MGNREG. There is a right to work or the right to food, right? These are neither fundamental nor constitutional right. Neither comes in Part 3 nor comes in Constitution. These are legal rights. So I hope you got that difference. Fundamental rights, constitutional comes in Constitution. In Part 3, directly you can move to Supreme Court. Constitutional right, it comes in Constitution, but not part of Part 3. You need to go to High Court if it is violated under Article 226. Legal rights are like the laws made by Parliament and the state assemblies. Something which is very important, which I want to discuss, is the doctrine of eclipse. Okay, so Article 13 and doctrine of eclipse. Two important clauses there for Article 13 that we need to understand. Clause 1, that pre-constitutional law. I hope you understand what pre-constitution. Pre-constitutional law, whatever laws which were there before the Constitution. Post-constitutional law means which are after the Constitution. So clause 1 is pre-constitutional laws that violate the fundamental rights become void to the extent of the violation. So Constitution came here, you have the fundamental rights. So there are pre-constitutional laws. Whatever laws which violate the fundamental rights will become void to the extent of that violation. Whichever part is violating, that will become void. Now, second, any post-constitutional law that violate the fundamental rights is completely void. So in the pre-constitutional law, whatever part is violating that fundamental right is void. Post-constitutional law, when we talk about, if it violating the fundamental rights, it's completely void. I hope this is very clear. So one is talking about pre-constitutional law, clause 2 is talking about post-constitutional law. So see, here is where the doctrine of eclipse comes from, right? And if you see this case, which case is important here is Bikaji Narayan versus State. So it is actually a very important case in this respect, a doctrine of eclipse, and it said that the pre-constitutional laws which are violating the fundamental rights do not require to be struck down. What is required is they can remain dormant until the conflict. If there is a conflict between the law and the fundamental rights, till the time the conflict is resolved, this will remain dormant, right? Like a shadow, like an eclipse. But Deepchand versus State case, that is there, the court said that doctrine doesn't apply to post-constitutional law. Those laws are void from the start, because when the laws are formed, then itself it is violating the fundamental right. So there is no such application of this doctrine of lapse for the post-constitutional law, but applicable in case of pre-constitutional law to the extent of that violation. Till the time that conflict is resolved, it will remain dormant also. But again, when it comes to Ambika Mills versus State of Gujarat case, the court reversed its stand. So it said that even the post-constitutional law can fall under doctrine of eclipse. So the concept actually evolved over a period of time. So that's what various judgments comes over a period of time. Society is evolving, we are evolving, the legal system is evolving. So now the post-constitutional laws also fall under the doctrine of eclipse. So doctrine of eclipse is applicable for pre-constitutional as well as post-constitutional. In case of Deepchand case, it was made very clear, but that was reversed in the Ambika Mills case. So what is the present standards? It is applicable for pre-constitutional as well as post-constitutional law. So guys, these are the three cases which are related to doctrine of eclipse. In case if it is asked in mains, you should be in a position to write the cases. That's why I've stressed upon Bikaji Narayan versus state case. Okay, and that is related to the pre-constitutional law. Deepchand versus state case, that is related to post-constitutional law, which is void from the start itself, but that stand is reversed, and the stand which is there in Bikaji Narayan case for pre-constitutional law, same is applicable in case of post-constitutional law as per the Ambika Mills case. So I hope now this discussion is very clear. Now, the bigger question that we need to answer is, can the parliament amend fundamental rights? Article 368, that gives parliament the power to amend the constitution, but can it touch the fundamental rights? Let's talk about the cases. In Shangari Prasad versus Union of India, so the court said yes, because constitutional amendments are considered laws under Article 13, Clause 2. So Shangari Prasad said yes, you can amend. But again, in Golaknath versus State of Punjab case, the court reversed its stand. So it said, so see why this is important, why these cases are important when it comes to mains, because they will ask you this as a question, so you need to write that evolution. In prelims, if at all they ask, I think they will ask about the present stand only. That is related to Keshavananda Bharati, and I hope all of you know. Why I am discussing these cases, whether it is Shangari Prasad case, it said yes. Then Golaknath versus State of Punjab, it said no, saying parliament cannot amend the fundamental right. Then parliament have come up with the 24th amendment, which added the word power to Article 368, which is again making it clear that the parliament can amend any part of the constitution, including the fundamental right. So Shangari Prasad case said yes, parliament can amend. Golaknath case said yes, no, parliament cannot amend. And then Parliament came up with 24th Amendment and made it clear that Parliament can amend. But then finally, the landmark Keshavananda Bharati judge, Keshavananda Bharati versus State of Kerala case, the court upheld the power to amend, yes, but said it must not violate the basic structure of the Constitution. So this is a basic structure doctrine. What are the basic structures? Like you can take the preamble and you can see that basically include judicial review. You cannot amend anything related to that, right? And then secularism, federalism, these are the basic structure of constitution. Now, another question that we need to discuss is related to the reservation policy. Article 15.4 was added to allow the state to make special provisions for socially and educationally backward classes. So this actually led that, paved the way for reservation. Now, if you look at Article 16.4, that allows reservation in public employment under two conditions. First, the group must be socially and educationally backward. That's the first condition. That group must be socially and educationally backward. And second condition, they should be inadequately represented in the public service. So this again can be asked in the objective questions, right? So first condition, the group must be socially and educationally backward. And the second condition, they should be inadequately represented in the public service. So again comes to this Indira Sawhney versus Union of India case 1992. The Supreme Court upheld the OBC reservation, but added 3 rules here. So this Indira Sawhney case is very important because it introduced a creamy layer concept. So first, why it is important is because creamy layer. So again, second important point that I have discussed is reservation should not exceed 50%. So the maximum cap should be 50%. And then when it comes to promotions, there is no reservation. But again, in 77th Amendment, which came in 1995, it reversed the, that last rule out of this, right? Here, we were talking about no reservation in promotions. Appointment is okay. But here, allowed SC/ST reservation in promotions through Article 16.4a. Okay, so now the present standards in promotion, there is no reservation, but for SC/ST, it is there through 77th Amendment, which Article 16.4a. I hope this discussion is also very clear. Indira Sawhney judgment case is very important because that introduced a creamy layer. Also mandated that reservation should not exceed 50%. Also made it clear that no reservation in promotion. That have made subjected to some change in the 77th amendment that, what did I say? That SC/STs, right? So in that case, in promotions also, reservation can be done. Another topic that I want to cover, this equality before law, equal protection of law. In the subsequent lectures, I will give a lot of details and examples for this because this is something which is very important for you to understand through different cases. So when we talk about equality before law, it means everyone is equal in the eyes of law. That's actually a concept borrowed from UK. Everyone is equal. The queen is equal. The king is equal. Everyone is equal in the eyes of law. Now, when we talk about equal protection of law, it means equals should be treated equally. That unequals should be treated unequally. So equals should be treated equally and unequals should be treated unequally. That's what you mean by equal protection of law, which is a concept borrowed from USA. So equality before law borrowed from UK. Everyone is equal in the eyes of law. Equal protection of law borrowed from USA. So this is why. Now, second case, if you take, that is why the reservation is valid. So it supports the protective discrimination. Equal should be treated equally, unequal should be treated unequally. So you can give reservations, right? So that is again a kind of upliftment that you are actually doing. So that's why protective discrimination, and in fact, this support protective discrimination under the equal protection of law, not under equality before law. If you go with equality, there is no concept of reservation. But if you go with equal protection of law, equals are equals, unequals must be treated unequally. So the protective discrimination or the reservation is valid. Now comes to Article 21. I'll discuss this in detail in one day session when we talk about fundamental rights. Okay, so we'll discuss this in detail. But again, Article 21 says no one shall be deprived of life or personal liberty except by procedure established by law. So I have to discuss what is procedure established by law in detail. Let's discuss that in the session on fundamental rights. So this actually checks the executive's action, not the legislature's law. Okay, so there should be a procedure. If you follow the procedure, it's perfect. So here, the law which is made is not checked. Law is made, but whether the executive is following the action, the law during the action is what they're actually checking. So that's what Article 21, in fact, also talking about. But again, when it comes to Maneka Gandhi case, so the court brought in the due process of law. So what is due process of law here? See, procedure established by law is there. That means it's not checking the legislature's intent. But when it comes to due process of law, the intent of legislatures also need to be checked. It means law itself must be just, fair, and reasonable. So when you make the law, first it have to be just, fair, and reasonable. So you're checking the law, the legislative action, at the same time the executive action. So when we talk about due process of law, it checks both. When we talk about procedure established by law, the law already established. Now you check the procedures only, the executive action only. But when it comes to Maneka Gandhi case, you are talking also about the executive as well as legislature. The law which is established need to be just, fair, and reasonable. So in fact, this expanded the scope of Article 21 and brought it very close to the American model. So now Article 21 protects you from both bad laws as well as bad implementation. Earlier, law can be bad, but implementation is what checked. Bad law, if implemented properly, it is okay. But now, bad law cannot be there. Bad implementation also cannot be there. So it also includes the concepts like the right to privacy, clean environment, legal aid, free trial, all part of natural justice, and expanded the scope like anything. Now, I'll be discussing all those in detail, guys. Don't worry about that. Let's also now quickly look at Article 32. Okay, Article 32 and 226, the difference. See, Article 32, as I told before, let you to go directly to the Supreme Court. If your fundamental rights are violated, that means Part 3, if there is a violation, you can directly go to the Supreme Court under Article 32. That itself was a fundamental right. Article 32 is also fundamental right. So Supreme Court also cannot deny that. Article 226 let you to go to High Court for both fundamental right and other legal rights as well. So there are various writs which again have to discuss in detail when it comes to the fundamental rights. So habeas corpus, that's actually preventing you from, prevents the illegal detention. Mandamus orders the public authority to perform the duty. Prohibition, that stops the lower court from acting beyond its powers. Next, certiorari. quashes an unlawful decision of a lower court. Quo warranto questions the legality of someone holding a public post. So habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Now, see, we have covered a lot of topics today. So this is what the quick recap of major topics, and we will continue doing this because this actually help you in the revision also. From the preamble, we discussed about different types of majorities. We discussed about the fundamental rights, duties also. And we also take a look at the key judgments and the constitutional remedies. So these are not just academic terms, guys. They actually shape how India is governed and how citizens are protected. So that's all what I want to discuss. These are, in fact, high yielding topics for both prelims as well as mains. And now let me know in the comment section if you find it useful. And if you want any other topics to cover, just let me know. I'll do that. Thank you so much for watching. See you in the next video. In case if you're looking for any courses or any mentorship program, check out the details in the description. So see you in the next session. Thank you so much.